You could lose everything you've worked for, your money, your home, even precious time with your kids. Divorce isn't just a breakup, it's a battlefield. And on this battlefield, the documents you sign are your weapons, or your downfall. In this video, I'm exposing the 5 documents you absolutely must sign to protect yourself, and the 3 you should never, under any circumstance, sign without an attorney's eyes on them first. Think your lawyer is automatically protecting you? Think again. The hard truth is, most divorce settlements are designed to move the process forward, not necessarily to protect you. And that means if you don't know what you're signing, you could hand over your financial future, custody rights, and retirement, in a single stroke of a pen. But here's the part nobody tells you: when you know which documents matter, and which ones are traps, you can walk into this fight with clarity, confidence, and control. I know this feels overwhelming. I know you're tired, stressed, maybe even broken right now. But stick with me, because I'm going to arm you with the exact roadmap to avoid the biggest mistakes that ruin divorces. Never, ever sign something in a divorce until you know exactly what it does to your money, your kids, and your future. That's the line between freedom and regret. Before we dive in, subscribe for more divorce tips that could save you thousands. Now let's start with the very first document, and it might be the single most dangerous one to get wrong. It's called the financial affidavit, sometimes called the full financial disclosure. And I don't care if you've got a little money or a lot of money, this form is the backbone of your entire divorce. Without it, the court can't set child support, alimony, or even begin dividing your assets and debts. So what is it? It's basically a sworn inventory of your financial life. Your income. Your debts. Your bank accounts. Your mortgage. Your credit cards. Your retirement accounts. Even your day-to-day living expenses. It's the court's X-ray into your financial reality, and here's the part that too many people miss: this affidavit is signed under oath. That means if you lie, fudge numbers, or forget something, it's not just sloppy paperwork. It can actually come back as perjury, sanctions, or even criminal fraud. I've seen people lose credibility with a judge over a single, forgotten, bank account. Once the court thinks you're hiding money, good luck getting them to trust you with custody, support, or anything else. One false move here can poison the rest of your case. So what do? You treat this form like it's a loaded weapon. Gather everything: your pay stubs, your last 2 years of tax returns, every single bank statement, credit card bill, mortgage, and investment account you've got. And if something is missing, don't just leave it blank, write unknown and explain. Judges respect honesty and precision more than perfect math. And let me give you the biggest insider tip here: if you own a business, if you have stock options, or if your finances are even slightly complicated, do not try to guess. Don't ballpark numbers. Don't hope nobody notices. This is when you bring in your lawyer, or even a financial expert, to help you get it exact. Trust me, the cost of professional help now is pennies compared to what you'll lose if you misreport and the court turns against you. And yes, I know what you're thinking, but what if my spouse is the one lying on their affidavit? Here's the truth: if they get caught, it blows up in their face. Judges hammer people for dishonesty. Your job is to make your affidavit bulletproof, because the stronger and cleaner yours is, the weaker their lies look by comparison. So remember this: the financial affidavit isn't just paperwork. It's the foundation of your case. Build it strong, build it honest, and it will protect you. Build it sloppy, and it will collapse right on top of you. And if you think the finances stop here, think again. Because this was just the starting line. The next document is the one that makes or breaks the entire divorce: the settlement agreement. And if you sign it wrong, you don't just risk losing money, you could lock yourself out of your future forever. If that shocked you, hit like so more people get warned about this. Now let's move to the second document, and I'll be blunt: this is the one that can save you from years of fighting, or lock you into a deal you'll regret for the rest of your life. It's called the marital settlement agreement, sometimes the separation agreement. Think of it as the master contract of your divorce. Every deal you and your spouse make: who gets the house, who keeps the cars, who pays child support, who covers debts, it all gets written right here. And once the judge signs off, it becomes part of your final divorce decree. That means it's legally binding, enforceable, and not easy to undo. Now here's the mistake people make: they rush. They're exhausted, they want the fight over, and they sign an agreement that's vague, incomplete, or sloppy. Let me be crystal clear, vague language is a time bomb. You might think you're saving yourself from arguments, but what you're actually doing is setting yourself up for future lawsuits. Judges don't like guessing. If your agreement just says, "We'll divide the debts fairly," or "We'll figure out the deed later," you are begging for the next courtroom battle. So how do you protect yourself? You make it detailed, airtight, and impossible to misinterpret. That means specific timelines. Who pays what, when they pay it, and how. If the house is getting transferred, you don't just say, "We'll transfer it later," you include a clause that says, "Spouse A shall sign and deliver a quitclaim deed within 30 days. No wiggle room. No room for games. And here's where a lot of people slip: retirement accounts. Your agreement must spell out exactly how those get divided, and it must reference whether a QDRO, that's a qualified domestic relations order, will be prepared. Without that language, your retirement split is just words on paper. The plan administrator won't honor it. Which means your ex could walk away with the money you thought was secured. I'll give you a practical tip I've seen smart people use: make the agreement require cooperation. For example, if your ex is supposed to refinance a loan, sign a deed, or turn over a retirement form, you write that they must do it by a specific date, and you make the court order enforceable if they refuse. That way you're not chasing them down years later. And listen, I get it, when you're in the middle of a divorce, you just want to be done. You want to move on. But don't let exhaustion trick you into signing something sloppy. A good settlement agreement ends the war. A bad one just changes the battlefield. So here's the takeaway: sign the settlement agreement when it's clear, complete, and airtight. Not before. Because this single document will decide not just who gets what today, but whether you're stuck fighting the same battles 5 years from now. And speaking of battles, the next one isn't about today's money at all. It's about your future. Because if you skip the next document, you could lose decades of retirement savings and pension benefits you already earned. Now let's talk about document number 3, and listen closely, because this one is a silent killer in divorce cases. People skip it all the time, and years later, they realize their retirement savings are gone. It's called the Qualified Domestic Relations Order, or QDRO. And here's the deal: if you or your spouse have a retirement plan, a 401k, a pension, or any plan covered under federal ERISA law, the settlement agreement alone is not enough to divide it. I'll say that again: the settlement agreement is just a promise on paper. It does not move the money. What actually moves the money, what actually forces the retirement plan to split those funds, is the QDRO, a separate court order drafted with precise legal language and then approved by the plan administrator. Without it, the plan administrator will ignore your divorce decree. And when your ex retires, they can take the entire account, leaving you with nothing. Decades of savings, gone. So why must you sign and file this document correctly? Because retirement plans aren't just state issues, they're governed by federal law. ERISA requires that the plan itself approves the QDRO before anything can be divided. No QDRO, no split. It's that simple. Here's where most people get burned: they assume their lawyer will handle it automatically. But QDROs are specialized, and not every attorney drafts them. In fact, some courts don't even push you to file one unless you ask. That's why you need to take ownership here. Hire someone who knows QDRO drafting, an attorney who specializes in them, or a certified QDRO specialist. And don't just trust the draft. You send it to the plan administrator and get written confirmation that they approve it. Only then should you breathe easy about your retirement split. Another practical tip: don't forget the fine print. Your QDRO should spell out survivor benefits, meaning if your ex passes away before retirement, your portion is still protected. And it should cover tax handling, because if you don't, you could get stuck with penalties or unexpected tax bills. A properly drafted QDRO ensures the division happens smoothly, without surprises from the IRS. Look, I know retirement might feel far away compared to custody or the house, but this is your future we're talking about. A sloppy QDRO can cost you hundreds of thousands of dollars over time. Don't leave it to chance. So here's the bottom line: the QDRO is not optional, it's essential. Without it, you could walk away from the divorce thinking you've secured half a retirement, only to find out later you have nothing. And if you think money fights are tough, wait until you hear about the next document, because this one doesn't just decide who pays what, it decides who your kids actually see, and how often. Let me tell you about the fourth document you must sign: the parenting plan. If you and your spouse have minor children, this document is one of the most important you will ever sign. It's essentially the blueprint for your children's lives after divorce. Think of it as the court-approved roadmap that decides exactly who your kids will live with, when they'll see each parent, and how major decisions about their future will be made. In many states, courts won't finalize your divorce without one. You either agree on it and submit it, or the judge imposes one for you. Now, here's why it's absolutely critical: if your parenting plan is vague, you're almost guaranteeing endless courtroom battles later. Broad phrases like reasonable visitation or shared decision-making might sound flexible, but in reality, they're traps. One parent's reasonable might mean every other weekend, while the other parent thinks it means equal time. And when there's no clarity, you'll end up back in court fighting over who gets the kids for Christmas, who decides what school they attend, or whether they can travel out of state. That means more money spent, more stress on you, and most importantly, more chaos for your children. But when the plan is detailed and realistic, it becomes your shield. A strong parenting plan doesn't just divide time, it anticipates conflict before it happens. It should clearly spell out daily schedules: who drops the kids at school, who picks them up, what happens if a parent is late. It should outline holiday rotations, not just the big ones like Christmas and Thanksgiving, but also birthdays, Mother's Day, Father's Day, even spring break. A good plan also covers decision-making authority: who gets the final say on education, medical care, religious upbringing, extracurricular activities. These details matter because courts rely on that document to enforce stability for your children. Here's a practical tip: build in a dispute resolution method. Don't just leave it at, "we'll figure it out." Require mediation before either parent can drag the other back to court. That simple clause can save you thousands in legal fees and spare your kids from years of tug-of-war. Also, if something is important to you, write it down. Want your child raised in a particular faith? Want to limit international travel without consent? Want to make sure sports or extracurricular activities don't get disrupted? If it's not in writing, the court may not enforce it later. The bottom line: a parenting plan is not just paperwork, it's the foundation of your children's stability after divorce. Get it right, and you reduce future conflict. Get it wrong, or leave it vague, and you're setting yourself up for years of battles. And once you've secured your finances and protected your children's future, there's still one more piece you can't ignore: a temporary safety net that shields you until the final judgment. The fifth must-sign document is temporary orders, sometimes called temporary support and possession orders. These are absolutely critical to lock down early in your case. Think of them as the rules of the game while your divorce is still in motion. They aren't the final say, but don't underestimate them. They control your day-to-day life from the moment they're signed until the judge issues a final decree, and in some cases, they can shape the momentum of your entire divorce. So what exactly do temporary orders cover? Everything that matters in the short term: who stays in the family home, who has possession of the kids on which days, who pays the mortgage or rent, how utilities and household expenses get covered, and even whether spousal or child support will be paid while the divorce is pending. Without them, you're standing in quicksand. The other party can walk out, stop paying the bills, cut off your access to joint accounts, or even take the children and disappear to another city, all while you're left scrambling for emergency relief. By the time you fight to get things back on track, the damage is already done. This is why acting quickly matters. The spouse who secures temporary orders first often sets the tone for the case. Judges don't like to disrupt the status quo, so if temporary orders place the children with your spouse or require you to pay certain bills, that pattern can influence the judge's final decision later on. In other words, don't wait. File early, and protect yourself before the ground shifts beneath you. Here's the practical side: if money is tight, don't be afraid to ask for temporary support right away. Courts can order income withholding, so support is automatically deducted from paychecks. No chasing, no excuses. And while it might feel tedious, keep records of every bill and who's paying what. That paper trail becomes invaluable when the court considers reimbursement, credits, or adjustments down the line. Remember, temporary orders are about stability. They stop the financial bleeding, keep the lights on, and give the children structure while the larger fight plays out. Without them, you risk months of chaos. With them, you secure breathing room, clarity, and leverage. And once those safeguards are in place, it's time for a serious warning: the 3 documents you should never, ever sign without an attorney. Because one careless signature could hand over far more than you realize. Before I reveal the 3 dangerous documents you should never sign, I also made a full video on the divorce settlement traps that ruins lives. Check that out if you want to catch traps most people miss. 3 documents you shouldn't sign, ever, without review. Document 1, the quitclaim deed. This one trips people up all the time, because it sounds harmless. A quitclaim deed is just a piece of paper that transfers your ownership interest in a piece of property, usually a house, as is. No guarantees. No promises. No protections. You sign it, you're out. Period. And here's where people wreck themselves: they sign a quitclaim deed too early, before the divorce decree or the settlement agreement is finalized, and suddenly they've given up the one piece of leverage they had. Think about it. That house may be your biggest asset. It may be tied to your share of equity, your bargaining power, or even your custody negotiations if the kids live there. The moment you sign the quitclaim deed without a matching settlement and court order backing it up, you're handing your ex the keys, literally, while you're left hoping they'll keep up their end of the bargain. And if they don't? Sure, courts can force compliance, but that takes more hearings, more attorneys' fees, and months, sometimes years, of waiting. Here's a practical way to think about it: a quitclaim deed should never go first. It should go last. Only after the judge signs the final order, and only after your settlement agreement spells out who keeps what and who pays what. At that point, the deed is simply the paperwork that enforces what's already guaranteed. Done in the wrong order, though, it's a weapon against you. So what do? Simple: match everything. Make sure the quitclaim deed lines up with the exact language of your settlement agreement and your final decree. Confirm with your attorney that the deed says what it should say. And never sign one casually just because your spouse insists it's just a formality. It's not. It's your ownership, your equity, your leverage. Because here's the brutal truth: once you sign that quitclaim deed, there's no rewind button. You've given up title, and the property may be refinanced, sold, or rented out without you ever seeing your fair share. That's why you only sign when it's ordered, only when it's matched, and only when every what if has been nailed down. And if you think losing your house is the only danger, think again. The next document is even worse, because it hands over something more valuable than property: your decision-making power. The second document you don't sign is a power of attorney in favor of your spouse. This one doesn't look dangerous at first glance. In fact, most couples have one. A power of attorney, or POA, is that document you signed back when things were good. It gave your spouse the ability to handle your finances or even make medical decisions if you weren't able to. Perfectly normal when you trusted each other. But in divorce? It's a ticking time bomb. Here's the trap: in many states, a power of attorney stays effective until the divorce is final, or until you revoke it in writing. That means if you never revoke it, your spouse could still walk into a bank and access your accounts, sell assets, or move money around, all while you're in the middle of fighting over those very assets in court. They might even still hold your medical power of attorney, meaning they could technically have a say in your healthcare if something happened to you. Imagine being in a hospital and the person you're divorcing still gets to decide your treatment. That's real risk. And here's the harsh reality: once a spouse acts under a valid POA, even if it feels shady, the damage is often already done. You can sue, you can fight, you can bring it to court, but by then, the money's moved, the account's drained, or the decision is on record. Undoing that is expensive, slow, and sometimes impossible. So what do? Step 1. Revoke any power of attorney that names your spouse, right now. Don't just assume the divorce papers magically wipe it out. Put it in writing, file it properly, and notify every institution that matters: banks, brokers, your employer's HR if they hold benefit records, even your doctor's office if you signed a medical POA. Step 2. Don't ever sign a new POA giving your spouse power during a separation. You might feel pressure to keep things simple or show good faith. Don't. That signature hands them control you may never get back. Because here's the truth: a power of attorney is more powerful than most people realize. It's literally handing someone else your signature. And in divorce, giving your spouse that power, or forgetting to revoke it, is like giving your opponent your playbook and your bank login at the same time. And here's the kicker, the last "don't" doesn't sound dramatic at all. It's standard, it's quiet, most people don't even question it. But sign it at the wrong time, and you could wipe out future claims you didn't even know you had. Third document you should not sign is broad releases, one-line waivers, or general, "I agree to everything" clauses without independent counsel. This one is the silent killer. It doesn't look scary. In fact, it often shows up as a single line buried at the end of your settlement agreement, something like, "Both parties release each other from any and all claims, past, present, or future." Sounds simple, right? Wrong. That one sentence can erase rights worth hundreds of thousands of dollars. Here's why it wrecks people: when you sign a general release, you're not just agreeing to what's in the settlement. You're waiving rights you may not even know exist. That can include survivor benefits on a retirement plan, claims if your spouse failed to disclose an asset, reimbursement for debts they racked up in your name, or even malpractice claims against professionals who mishandled your money during the marriage. In some cases, it can lock you into future tax liabilities tied to accounts or properties you don't even control anymore. Courts enforce these clauses, precisely because they're broad. One vague line, and the door slams shut. And here's the brutal part: professional ethics rules and state bar associations actually warn attorneys about these clauses. Why? Because they're so sweeping that even seasoned lawyers know clients need independent counsel before signing them. Translation: even your own divorce lawyer may not ethically be able to tell you it's safe to sign. They may have to tell you to get a second lawyer just to review that release. That's how serious it is. So what's the move? Never sign a broad release as is. If a settlement agreement includes one, insist on specifics. What claims are being released? What time frames? What exclusions? If it's retirement benefits, spell them out. If it's property, define which property. If it's debts, clarify whose debts and for how long. And if the language is vague or all-encompassing, stop. Get independent legal advice in writing before you sign a single letter of that clause. Because here's the truth: a one-line waiver can undo every protection you fought for in the rest of the agreement. All the financial affidavits, parenting plans, temporary orders, gone in a single broad release. That's why the smart move is to slow down, clarify, and protect yourself. You've just learned the 5 documents you must sign to protect your future, and the 3 that can destroy it if you sign too soon, too casually, or without counsel. Now let's pull this all together, because the real power is not just knowing what to sign, but knowing when, how, and why to sign it. Quick question: have you ever seen one of these forms slipped into your papers? Drop a comment below, I want to hear your story. So here's the bottom line. Divorce isn't just about breaking up a marriage, it's about protecting your future. The difference between walking away secure and walking away broken often comes down to the papers you put your name on. Sign the right forms. Your financial disclosure, done honestly, builds credibility with the court. A clear settlement agreement locks in property, debt, and support without endless litigation. A parenting plan keeps conflict out of your kids' lives. A QDRO, when retirement is on the line, makes sure years of your work don't vanish into thin air. And temporary orders. They give you breathing room so you're not drowning in bills or fighting over who has the kids while everything is still pending. Those 5 documents are your shield. But refuse the dangerous ones. Don't sign a quitclaim deed until the court order and the settlement back it up. Don't let a power of attorney keep your spouse in control of your finances or medical choices while you're in conflict. And never, ever sign a broad release or one-line waiver without fully understanding what rights you're giving away. Those 3 can strip you of leverage, money, and even future claims you didn't know you had. This isn't about playing games. It's about survival, protecting your home, your retirement, and most importantly, your children. And if you found this helpful, subscribe now, because my next video goes even deeper. It's called The Divorce Settlement Traps That Ruins Lives. Watch that next so you don't miss the traps your ex's lawyer is hoping you'll overlook. And if you're feeling overwhelmed, you're not weak, you're human. Courts and attorneys can help with the legal side, but don't ignore the mental and emotional toll. Divorce is grief and stress rolled into one. The Mayo Clinic and other leading mental health professionals recommend structured support, therapy, CBT, support groups, parenting counseling. These aren't luxuries, they're lifelines. You don't have to do this alone. Quick resources if you need help right now. 1. Your state court self-help center often has free forms and guides. 2. Legal aid societies and family law clinics can step in if money is tight. 3. And for retirement splits, hire a Qdaro specialist or a family law attorney who drafts them all the time. Don't wing it. And finally, the part 1 need you to hear clearly. This video is for informational purposes only and is not legal advice. Always consult a licensed attorney in your state.